a look at the facts of their plan, we'll see that injustice will thrive through their plan. Now, I'd like to go down the flow and respond to the affirmative arguments they made in the last page, showing that through their plan, legal representation will not be upheld, but secondly, injustice will thrive as a result of their plan. Now, first, I'd like to address the point of topicality. And you talked about how when you are thinking about essentially their plan of essentially getting rid of attorney fee limits, you are thinking of prisoners. And you can tag my response as facts over common knowledge. Facts over common knowledge. And he essentially used the common knowledge fallacy. He says that because you are using your common knowledge and you think of prisoners when you think of their plan, therefore this topical plan. But in regards to the resolution, when we actually need to take a look and see whether plan falls under the resolution or not, it's important to take a look at the goals and the action of their plan. When first we see the goals, it's actually to uphold legal representation for the prisoners, but what their plan actually affects is the lawyers themselves. And I asked him in cross-examination, I asked, will you actually affect Mr. Oriel in the case if you pass the affirmative plan? And he said no. And will you affect the lawyer? And he said yes. This is essentially what the affirmative plan will do. It will not affect Mr. Oriel. It will not affect the prisoners, but what it does affect is the lawyer itself. In the impact of this argument, you can tag this as contradicting the resolution. Contradicting the resolution. The entire idea why the affirmative is in this debate around presenting a plan is to uphold the resolution, but if they contradict the resolution, we are debating for nothing. And because of this, we cannot vote for the affirmative plan. Now, the next point they talked about how it was essentially, he brought up the point of the 95% of pro se litigants. He said because it's terminated means it doesn't actually go to the court, and that pro se litigants are, the number is not actually 95%, and essentially the attorney fee limits is not actually helping pro se litigants. And you can tag my response as a PLRA decreased pro se litigants. The PLRA decreased the percentage of pro se litigants. Now, he addressed the point of the evidence I read, talking about the 95%, and essentially, he did refute to that argument. But the part he did not read was the second piece of evidence which I read, that directly because of the attorney fees, the number of pro se litigants went down. And that's the evidence I did hand over to them. And what we can derive from this piece of evidence is if you get rid of the attorney fee limits, the number of pro se litigants will actually rise, because there's a direct correlation between the number of pro se litigants and the number of pro se litigants and the attorney fee limits. So essentially, their plan will do nothing for legal representation, because we see that because of the attorney fee limits, the number of pro se litigants went down. Now, he also talked about how we haven't actually shown why, he also talked about the point that there is no impact. This was in response to my point of flooding the courts. He said, why not just have these court cases in the court? Why not just essentially have these meritorious cases in the court system? And this really leads me to my disadvantage of injustice thrives. Injustice thrives. And my first subpoint, you can tag this as flooding the court waste resources. And this really goes back to my partner's speech, where we talk about because of the attorney fee limits, it actually prevented frivolous lawsuits. By getting rid of this essential law, it will actually flood the courts. By flooding the courts, we're wasting valuable resources. But secondly, it will drown out meritorious cases. And because of this, injustice will thrive in the court system. And this is an impact of why the plan cannot be passed. He also talked about the point of we are upholding democracy. And you can tag my response as no tangible impact. No tangible impact. And he brought up this whole backstory of how the court system essentially set up this attorney fee limits. But when we actually take a look at their plan, we have to see what is the tangible impact between their plan of upholding democracy and the effects that their plan would have on the court system and justice as a whole. They may uphold democracy, which is important, but what about after their plan? And we see this in injustice thrives. And I have the three subpoints and the three impacts you can take away from my speech. First of all, we see that because of the attorney fee limits, by getting rid of it, you will actually flood the courts. Secondly, it will drown out meritorious cases, but finally, it will not fix the injustice in the current system. You see it as a non-topical case, but if you go back to the story of Mr. Oriel, their plan will do nothing to fix the injustice in the current system. Because they are not solving the root issue, I strongly urge a negative out. Thanks so much.